what happened in MR versus MT is the following. And this is I found this judgment particularly interesting. There was an antenuptial contract signed by the parties after customary rights and prior to civil marriage. The court was called upon to determine the validity of the customary marriage. It was an appeal from the regional court. Now, if there was a customary marriage that came into being before the antenuptial contract, the parties would have been married in community of property. If there was no a customary marriage, the parties were married in accordance with the ANC, and this then became a point of some serious contention. The appellant sought a final decree of divorce claiming no division of the joint estate due to the marriage being out of community of property with an ANC which excluded the accrual out and out. The respondent contested the validity of the ANC, asserting a prior customary marriage. The court, the regional court, ruled in favor of the respondent, declaring the ANC invalid and granting an equal division of the joint estate. The appellant appealed, arguing the ANC's validity and asserting that it complied with legal requirements. Now, the question which was the basis of all this controversy was whether a customary marriage came into being. It follows: if there was a customary marriage, ANC invalid in community. If there was no customary marriage, ANC valid out and out. The court looked at the provisions of Section 3.1 of the Customary Marriages Act, and it was very interesting on what basis the court found that there was no antenuptial or there was no customary marriage. The parties at all times, according to the testimony, intended to enter into a civil marriage. The court essentially says that even though they did the customary rights, they did what they thought was the correct thing culturally, but they intended to have a civil marriage. So in terms of Section 3.1 of the Customary Marriage Act, remember, we have three requirements. The requirements are, number one, that the parties must be above the age of 18. They must both consent to be married under customary marriage, and the marriage must be negotiated and entered into. Very often we focus into the marriage being celebrated and entered into because that's the complex part of it. That's where you need to establish what's the culture that's applicable there, or what is the customary law system that is applicable. The court threw a curveball, and the court actually looked at the middle issue. The parties must both consent to be married to each other under customary law. And what happened here was the court said no, the parties did not. They intended to marry in terms of civil law. That's why they did the civil marriage. So the appellant and the respondent had determined their MPR as per the signed ANC. The court takes judicial notice that in black culture it is normal for the parties to first negotiate lobola and finalize those negotiations before they go to conclude the civil marriage in church or at home affairs. When they go to church or home affairs to conclude their civil marriage, it does not mean that they are changing their matrimonial regime from customary to civil. What it entails is that the parties have first observed their custom before concluding the civil marriage. It is also common in black culture for lobola negotiations to take some years before they are formally concluded. It is therefore not surprising that the parties commenced their lobola negotiations on 25 July 2009, but then only concluded their civil marriage on 27 January 2015. The court being turned on the court's view that the parties, having intended to enter into a civil marriage, did not consent to be married to each other under customary law. Very interesting judgment from Limpopo, and it's going to be interesting to see how the other divisions interpret this. Very, very clearly stated by the court under the pen of Khanyago J. Bundle page 123, summary page 9, ZALMP PHC 45.